Hello, everyone. Happy Sunday. Happy almost election week, right? This week's going to be exciting for all of us. Now, Tuesday is going to be crazy, although I don't think we'll know the results of the election Tuesday, but I will be tuning in to find out what's going to happen. I voted, I early voted. One of the benefits of being a US citizen is you can vote in federal, state, and local elections, right? And so my phone has been blowing up last minute asking if green card holders can vote. Unfortunately, cannot. You have to be a US citizen, right, to be eligible to vote. So, that being said, and I remember talking about this in the last presidential election. If you are a green card holder and you are eligible to apply for citizenship, I know it's like preaching to the choir at this point, but if you were eligible prior to this election, and you could have started that process a long time ago and been able to vote in this election and make a difference, right? But here we are, election eve, and I'm getting messages asking if they can vote. So the answer to that is no. But let's see, we have 4 years till the next election, so let's get on it, people. You can call my office, let's set it up, and get your application filed. Just a reminder, if you have been a green card holder for 3 years, if you're doing it on your own, 3 years. If you are married, if you're married to a US citizen, you have to be a green card holder for 3 years to apply. And then if you are not, or if you're doing it on your own, it's 5 years. Okay, so let's get it together. There's my number. And if you haven't done so, let's file and get approved and become a naturalized US citizen before, 2024, right? Okay. So that being said, I early voted, and we are ready in the Richards house to find out the election results. The last time we did this, my son was 4, and believe it or not, he actually, kind of understood what was going on, and now he's fully invested. So we'll see how it goes. All right, let me pull up my banner. So today, I'm extremely vocal about my political preference, and say it here that Trump has been disastrous for our immigration policies. So let's just see what happens this week. I know, colleagues have been mentioning expanding into other practice areas. I'll never give up, practicing immigration, but luckily, I do practice other areas. And so today I wanted to talk about another area I practice, which is estate planning, specifically, to within the state of Florida, right? Because estate planning is state specific, and I live in Florida. I'm licensed in Florida, and so I serve Florida residents only in this particular area. However, with immigration law and trademark law, it's federal, so I serve clients in all 50 states and overseas. Okay, but today we're just going to talk about estate planning, and within estate planning, specifically about naming a guardian for your minor children. So let me see. I made a banner here. So naming a guardian for your minor children. So, a lot of people will say, Hashi or Mrs. Attorney Richards, I don't have an estate. I don't need estate planning. I don't have an estate. I don't have any assets, or I don't have a lot, and I just have a house, and, things like that. And especially if they have children, my question to them, or my response to them, would be, your biggest asset actually is, or are, your children, right? Your minor children. That's your asset. That's your most valuable asset, right? Your children. And so we have to think about estate planning from that perspective. If you are listening, and please feel free to share this video, like it, comment it, share it with your friends that have minor children. Number one thing on your to-do list should be naming a guardian for your minor children or child, right? How do you do this? So in Florida, you would do this in your will. in your last will and testament, right? You would specifically name a guardian um, written down in your will. And we'll get into some specifics in a moment on how to do that, or how many to include, and all those things. But in Florida, parents are the natural guardian of their children, right? So let's say, for example, that you have a two-parent household, and one parent passes away. So the Florida law would naturally assume, and Florida courts would agree, that the surviving parent usually would be the guardian of the minor children, right? But sometimes that surviving parent may, for whatever reason, may become incapable of serving, or you never know what's going to happen, right? Think about also if both parents are simultaneously, and I hate to say it, you never want to think about things like this, but both parents are simultaneously killed in an accident, tragically. Then what happens, right? So this is why it's very important to have a guardian named in your will. You never want to think of this worst case scenario, but you kind of have to avoid another worst case scenario, which would be having your child raised by someone who you didn't want them to be raised by. Right? So that's something very, very important to think about. Also, you have to think too, okay, well, if I'm in an accident and my spouse does survive, or think if they were in the accident with you and they do survive, who knows if they'll not succumb to their injuries later on, right? A few months later, and then that child or children are truly left without a surviving parent. So that's another scenario to consider, right? So in the event that neither parent has survived, or if one parent is unable to care or unwilling to care, right? What do? You have to name someone in your will. And there's certain criteria that have to be satisfied for this person that you name to be able to serve, right? They have to be an adult. In Florida, they have to reside in Florida. If they're not non-resident, they have to be a close relative, right? They also have to be able to serve. They have to be mentally fit to serve. So you always want to make sure that you pick someone that satisfies all of these criteria for your guardian of your children. Okay, so I took some notes here so I don't forget to say all the things that I want to say. So, by the way, absent naming a guardian, if you don't name a guardian for your child, guess who gets to decide? Yes, the courts. And not that they're not so busy that they have nothing else to do but sit there and think about the best interest of your children. They are absolutely swamped. Courts are backlogged. So why would you leave this very important decision to courts, right? Who then have to listen to many family members or even friends battle over who will get to take care of your child or children, right? And so, ultimately it is the court's final decision, but if you have named a guardian in your will, it's a strong likelihood, great likelihood that person will be picked, okay? Because, the standard is looking at the best interest of the child. So again, very, very important to name a guardian for your child in your will. What are some advantages, right, of naming a guardian? The number one advantage is you know your child, you know your children, right? You know what would be in the best interest of your child. So you get to select that. It's the absolute protection for your child, right? Also, I would say peace of mind for you as a parent to know that this is a decision that's already been made, and that your child or children will be in really, really good hands because you've personally made that selection, right? You also know that this is going to be your first choice, not the court's first choice for your child, right? You personally invested and made this decision for your own child. So that's I'm hearing an echo. I'm wondering if someone's listening in the other room. And then another advantage is that you can minimize family conflicts, right? What does that mean? Because so say, for example, you haven't named a guardian, now it's in the court's hands. And so you may have your sister appearing, and then maybe grandparents and maybe a cousin, all saying, hey, you know what, in the best interest of my child, I should be the guardian. I should be the guardian. It's this huge, maybe huge family battle, which if you can avoid, why not, right? Why not be proactive? Also, so those are some main reasons. Let me see if there's any questions here while I'm going along. Happy Sunday. Hello, happy Sunday. All right, I got some comments here from my son. Love you, Mom, you're the best. Thank you, thank you. Love that. Okay, so let me remove this comment so I can just put the banner back up. Okay, so where was I? All right, so the guardians, right? Oh, so then after we've gone over the advantages of naming a guardian. All right, so should you just name one? Well, typically I recommend naming more than one. You have a first choice and then a second choice and then even maybe a third choice in case those other choices are no longer alive, I hate to say it, or unable to serve, or something has happened that's changed from the time you had the initial conversation with them till now. Okay, so, and I did say conversation, meaning don't, please have a conversation with these people that you want to name as a guardian. So it's not some complete surprise in the tragic event that you are no longer alive, right? And able to take care of your minor child. So, and also the other thing that's important too is that when you and your spouse are doing your estate planning, both of you really need to agree on a guardian or the guardians, right, that you're going to name, because what you don't want to happen is in the case of a simultaneous death that there's two conflicting guardians in each of your like your husband names one guardian and you name another one, and then it's up to the court again to decide who is the best, who would be the best person, who would be in the best interest of the child to be the guardian for this child. I mean, another battle, right? And also one thing I recommend too, and again, this is all Florida law. So if you're not a Florida resident, please consult with an attorney, an estate planning attorney in your own state. But the other thing I recommend is to name a guardian of the property and also a guardian of the person, right? Because you want to make sure that that's two different people. The guardian of the person is actually someone who is handling the living situation, the health care and the education of the child, versus the guardian of the property, which is controlling the finances and also any assets that are in, you know, this child's individual name. For example, if the parents were in I keep using car accident, a tragic car accident, and there's a settlement awarded to the child as a surviving child or children, this guardian of the property will be responsible for managing that. And it's sometimes good to name two different guardians because there may be a conflict of interest with that person controlling the money and also controlling your own living situation, the living situation and healthcare and education of your child. Okay, all right, so some items. Let me see if there's any more comments here. All right, greetings from Italy. Hello. Hello. Okay, so I have someone from Italy watching. How cool. Yes, I have my mom here saying it's very important. It's very important. And you know what? Not only is it important, it's something hard to do. I understand it. I mean, when I talk to clients, it's hard, you know, because no one wants to think about you predeceasing, you not surviving your child, right? Your minor child. But you know, this is like really the best gift that you can you can give to them. So what are some considerations, that you need to think about when you are selecting a guardian or guardians, right? So let's think about some things, some items to consider. Number one, does this person want to serve? Do they want to be a guardian? So what will that entail? Actually having a conversation with them, right? Picking up the phone. Now during COVID, yes, picking up the phone or doing a Zoom if you can't meet with them personally, and asking them all of the hard questions, right? Hi, you know, we are doing our estate planning, and we right, because again, if you are together with the other parent of this child, it should be a we conversation. We are doing our estate planning, and we would love, in the event that neither of us are here, we would love for you to serve as guardian, and talk about all the things. Are you willing? Are you able? Right? Those are some, and it's not a fun conversation. Maybe an emotional conversation, but one that's very important to have. And along those same lines, before you approach this person or these people, what I recommend to my clients is make a list. Both of you sit down and make a list of all the people that you think that you'd want to ask, and then you narrow down that list until you have maybe 3 or 4 people. And then from there, that's when these phone calls start. So are they able to serve? So you have to think about the age of the guardian, right? A lot of people immediately select grandparents, but you have to think, okay, now, if my child is 10 or I have children, in that age range, okay, they'll be an adult in 8 years. How old will grandma and grandpa be at that age, right? How's their health? So always have to take that into consideration. Where do they live? Do you want to uproot your child from everything that they know in their own community and have them move to a completely different state and start anew? They've lost you. Now they have to start anew, making new friends and all that jazz, right? So think about their residence. Also, do they have other children that they're raising? And this speaks to a broader point, is even if they don't have other children, what is your child's relationship with these possible people you want to name as guardian, right? Do they get along with these people, the grandparents or siblings of your siblings, or close relatives or close family friends? So that's very important to consider. Also, by the way, I always recommend naming, like if it's a married couple you're thinking about naming as guardians, don't name both. Name one or the other, because they may, unfortunately, they may get divorced, right? Or one may not, so they may no longer be together. So just name one person of a couple, right? Again, this is all generally speaking, so I'm not speaking to any specific situation, and it's not it's not legal advice that I'm giving. It's just generally speaking. Have to make that disclaimer. All right, so also another thing to consider is, what are these potential guardians' life views, right? Do they mesh well with how you raise your child? What are their discipline methods, right? For example, we use conscious discipline. So when I, actually, let me not talk about my specific situation and who we named, but so think about that. Are these parents or grandparents or siblings or whoever you're thinking about naming, are their parenting methods the same way, same type of methods that you have, right? Do they parent the same way as you? Do they parent with an iron rod and you don't, right? So all those things are important. Life views are important. It's a lot, but it's better to do all of this planning now and thinking now than later on having it not go the way you intended, right? So those are some good items to consider when thinking about it. Once you've done all of that and you've narrowed it down to, a few names, then you can have the conversation with them, finding out if they're able to do so and what it would entail, and if you want them to be the guardian of the property or guardian of the person. And then all this coincides with a bigger estate planning, right? Because then, of course, what I always recommend is having a trust for your minor child. And that trust can be created from the will through what's called a testamentary trust, or a pour-over will that goes into a revocable living trust, right? So you can have two methods to create this trust for your minor child. And then, of course, that trustee would be responsible for any assets left in the trust name, right? And I always recommend a trust just because you can arrange to not have an outright distribution at age 18, which I don't think any parent would want their child to receive a lump sum of money at the age of 18. So again, it's a part of a bigger estate planning picture, but number one, naming a guardian for your minor children should be top on your list, okay? All right, let me see if there's any other questions. Exactly, just like life insurance and auto insurance, absolutely, this is up there with the bigger picture. And people sometimes say to me, God, it's too many decisions to make, but it's one of the benefits of being a parent, right? It's one of the privileges and responsibilities of being a parent, of being a responsible parent, is that this is like your obligation, right? To make sure that you take care of your child while you're here, and also when you're not. And so we always have to prepare for these worst case scenarios and think about how better off your child will be if you've done all of this planning now and the unforeseen happens, right? Awesome. Okay. So with that being said, you can contact my office for a consultation, and we can go over your specific situation and go over what estate planning needs that you may have. Let me see here. I was going to pull up one more banner. I am doing great. How are you? Yes, living children. So if there's no other questions, I will call it a wrap for this Sunday, and then hopefully we'll be back next Sunday with some really good news as far as the election is concerned. I think my banner is really high today. All right, so again, homework. Please share this video with anyone that you know that is a parent or parents of minor children living in Florida, so we can get them situated. Oh, great. From Morocco. I love it. I have an international audience today. So let's get it together, people. Let's get it together with the planning for your minor children. And also, again, by the way, I was only speaking about Florida law, but in every state they have something like this, right? So please, if you're watching from another state, contact an estate planning attorney, get this information together, get it written down, and then you can just relax, right? You can relax knowing that your child will be, your child or children will be well taken care of. All right, everybody. I hope you enjoyed today's Facebook Live. I hope you found it informative, and go ahead and share it with everyone that you know. All right. I'll see you all next week. Bye-bye.